Could it really be possible that Gerry Adams, the former Sinn Féin president, gets compensation from this government because he was interned without trial in the 1970s? At the moment he is blocked, but the Act of Parliament that blocks him and others from getting that compensation is, it seems, being repealed. Let us talk to Professor Richard Ekins KC, who's Professor of Law at Oxford and also head of the Judicial Power Project at the think tank Policy Exchange. Good morning to you.
Good morning.
What are we talking about? What is the law at the moment, and why is it the law, and what's the proposed change?
So in 2023, Parliament enacted the Northern Ireland Troubles Act, and two provisions of that long and complex act, two provisions reverse a Supreme Court judgment from 2020. And the effect of those two provisions is to stop Gerry Adams and 300 to 400 others from claiming compensation. And it also, it restores the law as it was up until the Supreme Court judgment in 2020, a judgment that badly misconstrued the law as it had stood from 1972. So the law in 2023 is a bar on claims for compensation. The government are now proposing to use their powers under the Human Rights Act to repeal those two provisions, which will make it possible for Gerry Adams and, as I say, 300 to 400 others in a similar position to claim compensation.
And what do you make of that?
I think it's a very ill-considered decision. I think it's constitutionally outrageous for the government to be proposing to override legislation enacted without controversy in the Houses of Parliament in 2023. There was controversy about other elements of Northern Ireland policy, of course, but these two provisions, reversing that 2020 judgment, by the Supreme Court, that was unanimously supported, including by the then Labour opposition. They're now proposing to reverse it, and they haven't given any reason, let alone a sort of satisfactory reason. The only explanation you can find is that in February last year, a single High Court judge in Northern Ireland declared that the 2023 legislation, this part of it, was unfairly retrospective, incompatible with convention rights. As I say in a new Policy Exchange report today, which is backed by 16 distinguished peers, that declaration was clearly wrong, should not be accepted. The government should have maintained an appeal against that declaration, but I think foolishly it abandoned it, and now it's proposing, at least, to go ahead and repeal the legislation.
And what they seem to be saying, what they are saying, is that they have to do that in order to follow human rights laws.
It's just not true, if they are saying that. So what they had a choice as to whether or not to maintain the appeal. They chose to abandon the appeal. Very foolish decision. This was a clearly winnable appeal. My Policy Exchange report this morning sets out a pretty exhaustive critique of that High Court judgment in this respect. It's backed by some of the top former judges in the country. The government certainly should have maintained the appeal. And even if the Court of Appeal, or in the end the Supreme Court, had made the same decision, it remains under our Constitution, under the Human Rights Act itself, it remains up to the government to decide whether to use its ministerial powers, to try to repeal or amend legislation. And it remains up to Parliament as to whether to accept it. So the government may think it has no alternative, but if the government's thinking that, it's clearly misdirecting itself.
Right, so what should it do now?
What it should do, so it's tabled a draft remedial order before Parliament. It's still time, clearly, for the government to amend its draft remedial order, exclude this part of it. It can tackle the other things that it thinks is wrong with the 2023 Act, but it should not be addressing these provisions, which block Gerry Adams and several hundred others from claiming compensation.
Okay.
It should not be addressing them in this way. If it wants to come back to the question, then come back with primary legislation. It's promised to come back with a bill to repeal and replace the whole Act. So it's quite improper, frankly, wholly inappropriate, as Lord Hope said in his preface to our Policy Exchange paper, for the government to be trying to do this by ministerial powers and bouncing it through Parliament.
OK, well, we'll be talking to a minister at 8:10, and this may well come up. Professor Richard Ekins KC, thank you.